Welcome to the 25th episode of Supreme Myths. And I wanted to invite somebody extraordinarily special for this episode. And I think I've done that. A friend of mine, he is the Cornell professorship. He holds the Cornell professorship of law at UCLA Law School. His name is Adam Winkler. He has written two amazing books, one called We the Corporations, How American Businesses Won Their Civil Rights, and two, what you probably already know him for, Gunfight, The Battle Over the Right to Bear Arms in America. We're going to talk a lot about these books because they are two of the best legal books I've ever read. Adam is one of the 20 most cited law professors in judicial opinions today, which I think is actually a really good honor. Like, there aren't that many good honors we get. That's a good one. When judges are citing you, you know you've done something really right. Adam, welcome to Supreme Myths.
Thanks so much for having me, Eric. I'm a big listener of Supreme Myths and happy to be a guest for once.
Thanks. I have to mention this, and I hope you don't get mad, but you were so kind to invite me a couple years ago to do a book talk on my book, Originalism as Faith. And I was staying in LA, about 45 minutes, I thought, from UCLA. And the thing was at 12. I got to UCLA 11:05 with a parking pass. And it took me an hour to get into a parking lot and into the room, which was much more adventuresome than getting from Irvine to downtown LA or wherever you are, westward, where I was. Anyway, I appreciate you inviting me to do that. It was fun. All right, so we're going to talk about a lot today, but we want to start with current events. This is being taped on Monday at 1 o'clock Eastern time, and the impeachment trial for former President Trump, which has a much better sound to it than President Trump, starts tomorrow. So some law professors are divided on the question whether the Senate can try a person who is no longer in office. Do you have any thoughts about this?
Well, I think that there's no question that the Senate can try someone who has already left office. And in fact, the Senate has done it before, right? This is not a first. It's a first for the president of the United States, but there's nothing in the impeachment clauses of the Constitution that separates and distinguishes the president from other people who are holding office under the United States. First of all, I think that it's important to recognize that the framers themselves were very well aware that someone could be impeached after leaving office. During the Constitutional Convention, there was a British governor by the name of Warren Hastings. Warren Hastings was impeached by Parliament 2 years after leaving office. So, and even during the Constitutional Convention, the impeachment of Hastings was referenced during the discussion, although not with regards to whether it was permissible to impeach someone after they had left office, but nonetheless, they were talking about an impeachment approvingly that was happening under English law at the time, right, of someone who had already left office. John Quincy Adams said that he would be subject to impeachment after he left public office. He thought that the impeachment power extended that much. And we know that there's a specific instance, a history and tradition, if you will, of the Senate impeaching people the House impeaching and the Senate holding a trial to disqualify someone from public office after they had left office. In 1876, President Grant's war secretary, William Belknap, was impeached after he resigned. And there was a debate in the Senate on this very issue about whether someone could be impeached after leaving office. And the Senate voted ultimately to carry on with the trial. And although Belknap himself was not convicted in the trial did proceed. And the idea that the impeachment was inappropriate was overruled. And the key here to remember is partly it seems odd to have an impeachment trial for someone who's left office because we often think of the impeachment power as being about the removal from office of an officer. However, the impeachment clauses envision two punishments: removal of office, but also disqualification from future office. And even if someone's left the office that they were elected to, as President Trump has done, there's still a question about whether they should be disqualified from office in the future. And so the impeachment power, by its very nature, envisions punishment after someone has resigned. after someone has left office with this additional punishment of disqualification. There's good founding era evidence to support it if you're a believer in originalism. And as the court has often done, it's often looked to history and tradition to make this decision. And there is a history and tradition of impeaching people after they've left office. So I think it's a pretty clear-cut case, and I don't think any court's ever going to rule on it with regards to Trump. And I think the Senate is going to go forward with their impeachment trial, despite the objections.
And if text and history weren't enough, there's the policy that obviously we don't want people resigning 5 minutes before their impeachment trial begins. That would be bad policy. You and I agree the court wouldn't hear it anyway. I think that's very obvious. Yet there is this debate that's going on about whether the Senate can do this. And that leads me to a kind of tangential question about social media. You're on Twitter a little bit, but you write a lot of op-eds and a lot of essays, and you've been published in every major newspaper in the country. So Bruce Ackerman, who is the Sterling something or other chair at Yale Law School, and clearly one of the most respected, famous con law professors, in the last 50 years, he writes this op-ed in the Washington Post that says no, that it doesn't really justify it. In one paragraph, he says they can't try him because he's already left office. And by the way, he was impeached before he left office. We shouldn't forget that either, right? I mean, the House did impeach him while he was in office. But leaving that aside, Bruce's op-ed, I think, triggered this whole debate. Without Bruce's op-ed, because he's a liberal, I'm not sure we have all the discussion. And you know that 45 senators have already said they don't think that he should be able to be tried. What does that tell us about the law, social media, and influencing today?
Well, that is influential. And by the way, we might note that today there was an op-ed by Chuck Cooper, who is a very conservative lawyer who is represented the NRA for ages, worked in the Reagan and Bush White Houses, in the Office of Legal Counsel, really one of the eminence gris of the Washington legal community. He wrote an op-ed saying, of course you can try someone after they've left office. So right. We are seeing some odd bedfellows with some liberals saying you can't, and some conservatives saying you can. I think what it really shows is there's a real difference between academics who are really interested in ideas and trying to figure out the right answer, and thoughtful critics, people like Chuck Cooper, not an academic, but thoughtful nonetheless, who are willing to challenge their preconceived notions and to think about the law outside of the context of how it applies to your favorite political candidate. What we saw in Congress is that 45 people who didn't really think that much about the impeachment question and the constitutional issues involved nonetheless voted in that way, primarily because they want to see that their favored political candidate, Donald Trump, immune from any kind of punishment or retribution for what's happened. I want to say that I work for... Right. So I think it's a compliment to Bruce Ackerman that he's willing to take that view. I disagree with him, but look, we operate in the world of ideas, and they're not just the world of ideas, but it's part of our obligation to share those ideas and how we think about these contested questions with the larger public and to stir and spark debate.
So I'm going to push back a little bit, which is okay. I think we're friends. I worked for Chuck Cooper actually when I was at the Department of Justice, and not directly because he was an Office of Legal Counsel, but I had cases where he was involved. He comes from a generation of Republicans like Charles Freed at Harvard and others who have been against Trump from the beginning. So I hope he's being sincere in his views. He is not in any way, shape, or form a political ally of Donald Trump. He's the old Republican Party, which wasn't great, but it's a lot better than the one that we have today. The other thing I want to say about Ackerman is the reason that paragraph his op-ed wasn't about this. That op-ed was about Section 3 of the 14th Amendment, which I've discussed previously with Keith Whittington here and some other people, which says you can't hold office after you've been engaged in an insurrection against the United States. And Bruce's entire pitch in that op-ed was we should use Section 3 of the 14th, not impeachment. So I do think there were political things going on in the background of both Cooper's and Ackerman's op-eds that maybe don't distinguish academics from politicians quite as cleanly as you suggested. I have a more difficult question. And this is where I disagree with progressives, which, as you know, happens to me a lot. And then I get yelled at by my friends and I go home and I'm sad. I am not at all convinced this is good strategy. and I've yet to meet a progressive who agrees with me, so I'm going to say I'm probably wrong, but let me make my case and you tell me why I'm wrong. They're not going to get an impeachment. They're not going to get a conviction. I think they might, but it's like 95% chance against. So Democrats, and Jamie Raskin is a friend of mine. He's leading the trial in the Senate. I actually used his office for a semester once at American. Jamie's a great guy and he's very reasonable. But he's going to lose, and Democrats are going to lose. And that gives me two big pauses. One, a loss is going to be viewed as exonerating him from his participation in the insurrection. And I think that's really bad. I think because he was involved, and I think that's really bad. Two, I think there's going to be all kinds of First Amendment craziness thrown into this where it does not belong. And I think this country throws enough First Amendment stuff where it doesn't belong as it is. And this is going to do it more. Because people are going to say he was just speaking, he was just talking, and it was political speech, the most protected speech. We can't punish him for that. So I'm not sure this is a good strategy. Tell me why I'm wrong.
Well, I should say that I don't know that you are wrong. I can't claim to be a great strategist of American politics. And I find that what my predictions about American politics are consistent in one way, that they're usually wrong. So I don't know, that you may very well be right. I mean, I could see arguably that, if you didn't impeach him in light of what's happened, that would be a kind of exoneration too. It would be a kind of, hey, we don't think he's responsible, and that we think that this kind of behavior can continue. I think the prospect of impeachment, even if he's ultimately acquitted, even if they don't find a conviction, it does show that there's a little bit of pushback for this kind of behavior. Interestingly enough, I think actually the strongest pushback, and I think it's a more successful strategy, is not going to come from impeachment, but come from defamation cases that are being brought by some of these voting technology companies, like Smartmatic and Dominion. Like we've already seen, like nothing, all the liberal outrage you can muster for years hasn't stopped Fox News from promoting disinformation and lies and craziness about America. One lawsuit and 2.7 billion lawsuit, and Fox News cancels its most popular, most watched TV show, Lou Dobbs Tonight. So, maybe there are other ways in which we are going to have a kind of accountability for what's happened in the last few months. I do think that it's important to take a stand against the kind of disinformation that we've had. What happened in the last few months has really fundamentally undermined American democracy. And I think a lot of people, when it began in November with Trump's outrageous comments about the election being stolen, a lot of people were like, oh, well, you know what? Finally, he's going to be leaving the stage and we just don't have to worry about it. We can, allow him to pursue his claims, use the legal process and the judicial process. But we see where that resulted. The result of that was ultimately an insurrection at the Capitol, an attempt to stop the counting of the Electoral College votes. That this happened from the political party that claims to be the only one that adheres to the Constitution and believes in it is just one of the great or sad ironies of the Trump years.
Yeah, and we'll get more into that in a minute. I was raised in New York. Anybody raised in New York who's my age, 63, knew that Trump was not going to go quietly, knew that there would be a disaster at the end of this. And anybody who thought differently has not been paying attention at all to this man, not for 4 years, but since 1989. I mean, since he's been in the public eye. So, money speaks in America. It's funny how Fox News can be pushed off of its ideological priors when money's at stake. And we'll talk more about that when we talk about your amazing book, We the Corporations. But before we get there, so you live in LA, you live in, I assume, somewhere near Westwood or in Southern California. So before we get to the court's heinous decision on Friday night, I'm not going to pretend to be objective about it. I think it's heinous in every imaginable way. Before we get there, what's it like in Southern California? I mean, because, in Georgia now, it's 35 degrees, 40 degrees. Some days are warmer, some days are colder. We're not really outside all the time. So, but you guys have weather that, usually lets you be outside. What's it like? Is it? Yeah.
Well, I think like the answer to that question, I can't answer that question without recognizing the privilege lens that I look through, right? I am a reasonably wealthy white guy who lives in a nice part of town and still has my job, and my job does not require me to actually interact with other human beings on a one-to-one basis. I can do my job on Zoom. My wife's in the same way. She's got a nice, good white-collar job that's still paying her to be on Zoom. My daughter is 17 and she's in school and still doing school on Zoom, and she's not of one of those ages where it's really, really awful to be on Zoom. It's bad, but it's not as awful as, say, a kindergartner or a first-year-old. So my experience is really, really goes through that lens. And my own personal experience is that, you read the newspaper and it's super scary, but my life is basically a life of isolation as it's been since March of 2020. So nothing's really changed out here. We don't really see it as on a day-to-day basis. I'm not in the hospital seeing the overwhelmed emergency room staff or ICU staff. So I don't, I read about it every day, but these things are very community-based. Talk about Los Angeles as being the epicenter right now of the COVID crisis. But there was an interesting article, I think it was in the LA Times, maybe it was in the New York Times or the Washington Post a week or so ago, that sort of broke it down by areas of Los Angeles, communities in Los Angeles. And it turns out there are some communities where people are working class, who especially immigrant communities, who all live on top of each other because they don't have the money to afford the nice houses we have on the west side of LA near UCLA. That's where COVID's really spreading, and about 1 in 3 people have COVID in some of those communities. In my community, that same article has found it's about 1 in 25, and the numbers haven't really changed much in the last 6 months, because people in my community have the means to be able to remain socially distanced, to continue our jobs without it. So it's really devastating, but it just highlights once again how privilege impacts health outcomes, life outcomes. And it's just one more opportunity, I think, at least for those of us who have that privilege, to recognize it and to remember our responsibility to those who don't have it.
Yeah, I think that's well said, Adam. I mean, money speaks kind of the theme so far of this episode of Supremacist, and it's not going to go away. So on Friday night, the Supreme Court overturned the governor's rules prohibiting indoor religious services. And I have a piece coming out. This is Monday. By the time this airs, it'll be out. But I have a piece coming out in the ACS blog on this. And in doing research for it, I learned that California's economy is bigger than any economy in the world, say 5 countries. And then, so it's the 6th largest economy in the world, I guess. And then thinking about San Francisco versus LA versus San Diego versus Sacramento versus the rural versus the urban, it's like governing a country. I mean, it's that California is that big. Of course, everybody knows. And so what the governor did is he banned things that are like indoor religious services, like movie theaters and places like that where people congregate together for long periods of time. And if a bunch of people wanted to have an all-day meeting on freedom of speech, if the ACLU wanted to have an all-day indoor meeting, no, they can't do it. So it applied to speech, it applied to religion, it applied to everything that's like religious services, which is what you'd hope during a pandemic a state would do. They would do it carefully, and you have different rules for different counties and different rules for different times, depending on what percentage of the people are infected. I think I saw over 1 million people are infected in California. It's all terrible and crazy and complicated. Yet Friday night at 11 o'clock, they couldn't do it at 4 o'clock for the news. At 11 o'clock, the 6 conservative justices strike down this ban on indoor religious services. And they upheld a ban on no singing, which to me is a no-brainer. You can't have people in a room singing during COVID. Like, that's just, that's obvious. But the 6 of them struck this down. And with almost no reasons given. And Justice Kagan cites a bunch of scientific data in her dissent, in a very short dissent, why California did this. And they don't even deal with that. They just say this is what we call strict scrutiny, and California should have done better, and therefore it's reversed. Do you agree with me that this really is a horrible thing for the Supreme Court to be involved in?
Yeah, I think the Supreme Court's definitely making a mistake here in this instance, and what we see is sort of the manifestation of the Trump justices and the Trump influence on the Supreme Court. The Supreme Court was already conservative before the 3 Trump justices were nominated, Justices Gorsuch, Kavanaugh, and Barrett. But those 3 justices have, joined in. They didn't join Barrett and Kavanaugh didn't join Gorsuch's opinion in full. But in general, they supported the idea that these limits on church proceedings are unconstitutional. And it shows that we're likely an area of constitutional development we're likely to see in the next few years with the new conservative Supreme Court is an expansion of religious liberty rights under the Constitution and a real calling into question about whether generally applicable laws can be applied to religious believers. This is an issue that I think we're going to see more and more cases raising it. We've already seen it on issues like LGBTQ rights, such as whether businesses that provide wedding-related services can refuse to offer those services to same-sex couples, despite laws that say you can't discriminate on the basis of sexual orientation in those states. And the court has called those, has basically said in Masterpiece Cake Shop, for instance, that it's likely that those businesses have a religious freedom right to discriminate in this way. And so I think it's sort of disastrous to expand religious freedom in this way. I mean, I think there is, and there's plenty to complain about with regards to Gorsuch's opinion. California made a number of arguments, right? It said that the reason why we're going to keep churches and treat them in this way and a little bit differently from, say, like retail establishments is because there's a constellation of things that happen in church services. You have gatherings of people for an extended period of time. You have people who are gathering who are not from the same family gathering for a lengthy period of time. While they're gathered for a lengthy period of time, they're singing out loud and chanting and otherwise actively expelling the aerosol particles that are so problematic. And what interesting what Gorsuch does is an opinion. He says, well, let's take each of these arguments in turn. And he says, well, look, California says that, that people will gather people from different families will come together. But he says, look, there are other parts of the economy in which California is letting people of different families come together. Go to a supermarket, you'll see people of different families together. And then he says, well, let's look at the singing thing. Well, but California allows singing in some other situations, such as in a Hollywood film production, you can have some singing. And what part of the problem here is that he breaks down the argument that is a combined argument, that all these four things come together, it causes a problem. Right. And he says, well, let's take each one of them in turn and compares it to a situation that doesn't involve all four of them together. And so it's just poor reasoning, I think, and poor argumentation. One good thing I think about the opinion is I do think that California and some other states have shut down a lot of things like religious services, and perhaps they could think of other ways to go about doing it. And if the court's opinion encourages them to take other approaches that might be more respectful of religious freedom, but still meet the public's demands for public safety, then maybe it could be a good thing. So for instance, no one's allowed to participate in those church services under the old rule. But you could have Hollywood filming. Now, that's not an equivalent because anyone who goes to a Hollywood film set has to get tested first. And there's a regime of testing for everyone who goes onto that film set. Well, why not offer churches the opportunity? If you want to have in-person meetings, you can have them, but you have to have rapid tests for everyone who comes in. And of course, you have to have social distancing and other measures, or maybe you restrict the singing. It does seem like the singing ban is now allowed because Justices Barrett and Kavanaugh agreed that the singing should not be, the singing ban was not constitutionally questionable. So I don't know, there is an area where maybe we could have more encouragement of public health officials to think of creative ways in which they might respond to some of these problems and still respect religious freedom.
Singing is, for the moment, allowed to be banned, although there's some hints that might change. But speaking in unison, I don't think is singing. And I don't know if that's banned or not. Chanting and singing are banned. I'm not sure about speaking. But that raises the point, Adam, I want to make, which is, okay, so this, I think, I'm not sure yet, but I think this podcast, whatever audience it has, however small it is, has both law professor, lawyer types and non-legal types. For the law professor types out there, what made me so mad about Gorsuch's opinion is that it basically reverses the Smith case without admitting they're reversing the Smith case. I don't want to debate that too long, but Scalia wrote Smith and said generally applicable laws, not targeted at religion specifically, don't raise free exercise concerns. I agree with Scalia about that. And this opinion undercuts most of that decision. They could at least be honest they're doing it. So that's one way the court is not acting like a court in that sense. Be honest. Say what you're doing. But for the non-experts out there, I don't think we have to get drugged down or mired down in doctrine to say this is an emergency. It's really hard. California is not Idaho, which is pretty homogeneous. And, California has like 5 different states all in one. And absent really unreasonable actions, why are life tenured unelected judges second guessing these these decisions that are made in consultation with scientists, as Justice Kagan pointed out, scientists and others, which leads me to my question. In his very short statement agreeing that the ban on religious services should be reversed, Justice Roberts said something I know you're going to know makes me so mad, but I'm not sure it's going to make you quite as mad. He said, we need to do this because we're life tenured. Justice Kagan had said life tenured judges shouldn't be doing this. If there is death because of this, we'll suffer no political ramifications, as opposed to California officials who have to be elected and so on. And Roberts said we have to do this because we're unelected and life tenured. To me, being unelected and life tenured means humility, modesty, and don't second guess absent the most compelling of reasons. And that's why that sentence of Roberts made me really mad. I'm wondering how you feel about it.
Well, Eric, I mean, you're kind of famous for thinking that the court just should just stay out of everything. So I'm not
infamous, maybe
that
infamous.
They should stay out of this. I'm kind of torn on it, to be honest with you. On the one hand, I get where you're coming from, and I share your view that the court generally, when it steps into these matters, tends to get things wrong. But of course, American history is filled with examples where the court decided there was an emergency, and so we're not going to second guess executive branch officials, either at the federal or at the state level, to disastrous results, right? We don't have to think much past Korematsu versus United States, where the court upheld the internment of Japanese Americans. We saw the Roberts Court in the Trump versus Hawaii on the Muslim ban case. The court kind of took that.
But Adam, if I may, I don't mean to interrupt, but I'm sorry. On Twitter, someone threw Korematsu at me. But here's the irony. These judges would have upheld what happened in Korematsu. And that's the problem. And we know that because they upheld the Trump ban, as you were about to say before I rudely interrupted you. But the bottom line is these justices would have been on the side of the president in Korematsu. So what's really going on here is we have 6 religious judges who think religion takes priority over everything. And maybe they're right and maybe they're wrong. But we didn't vote them in. We can't vote them out. And they would have done the same thing the majority did in Korematsu. So the Korematsu argument doesn't appeal to me all that much.
Well, but that's a charge of hypocrisy against these particular judges. It's not actually a statement about whether the court should be involved in those cases as a general matter, right? I mean, Korematsu is wrong, and the fact that other justices might repeat the error, and I think they, in many ways, did repeat the error in the Trump case, right. That just highlights that it's in error and that we want the court to second guess, even in context of an emergency, and that an emergency should not be an occasion for the court to say, well, we just have no power to act here. I do think that emergencies should weigh on the court, and the court should have a little bit more deference to lawmakers, especially when there's a public health emergency that's going crazy. I mean, the justices must know that Los Angeles is the epicenter of this COVID problem right now, and yet they aren't doing much to help things. But nonetheless, I do think that there is some role for the court to play in these matters, and it's not so easy to say that, well, justices shouldn't be involved at all. I do share, though, Eric, your sense, though, that these particular justices, if they're going to get involved, it's going to be a bad decision. So maybe we just don't want the judges making bad decisions.
Forgive me for this indulgence. I hope you understand it. I think the history of our country shows that an institution that gives governmental officials life tenure and effectively unreviewable power shows that they will simply vote what they think is politically best in the highest stakes political cases. You wouldn't even know, I don't think, reading Gorsuch's opinion, that LA County is the epicenter of a lot of suffering right now. I'm not even sure they gave that very much weight at all. And LA County itself is bigger than like a lot of states. Okay. So I want to talk about your two books because I love these books, and I say I tell it to all my guests I love your books. I usually mean it, but in your case, and you know this from our past, I really, really mean it. I mean, because you. Okay, so in case people don't know, your father is a famous Hollywood producer. We may talk about that later. Movies like Rocky and The Right Stuff. Right Stuff's one of my favorite movies ever, and so on. You tell a great story. So you pick these highly charged issues, Citizens United, basically, and money campaigns and corporate speech, and of course the Second Amendment. And you write these books that read like novels, and you learn so much. So I cannot tell people enough, go read these books. The more recent one, We the Corporations, How American Businesses Won Their Civil Rights. If you can do it, I don't know if we can do it in the time we have, the story of how the Supreme Court decided that corporations were persons under the 14th Amendment is an amazing story. And it's full of chicanery and devilishness, all the things I hate about the Supreme Court, it's full of, which of course is why I loved it. Can you tell that story in a brief period of time, or was it too long?
Sure. It's actually one of the most remarkable and astonishing stories in American constitutional law history. And in some ways, I was inspired to write my book about corporate rights by Citizens United, but also the desire to tell this story. Because I had studied the Constitution for years and didn't know the story. And it's a story.
I never knew it until I read your book, Adam.
Really? You never heard that story, right? And so... And that's one of the great things that the things I've really enjoyed about writing the books that I've written is that people who know a lot about the Constitution, like you, Eric, but no one studied it more than you. If I can tell some stories and provide some insights that people who've really thought about it a lot haven't seen or haven't heard those stories, that's rewarding to me to help to expand our base of knowledge. And the cases that you're talking about are a series of cases in the 1880s where the Southern Pacific Railroad, the big behemoth railroad of the West, sought to win rights under the 14th Amendment to the Constitution. The 14th Amendment, as all your listeners probably know, was adopted in 1868, right after the Civil War, to guarantee equal protection of the laws, among other things, to the newly freed slaves. And in the 1880s, the Southern Pacific Railroad sought to expand the equal protection guarantee to corporations, too. At issue in the cases was a California law that taxed railroad property differently than other kinds of property. And the railroad said, this discriminates against us. This is just outright discrimination. And they take their case up to the United States Supreme Court, arguing that the 14th Amendment protects corporations, too. They hire as their lawyer.
I'm sorry, because it says persons. It doesn't say corporations. It says persons.
The 14th Amendment says no state shall deny to any person within its jurisdiction the equal protection of the laws. And the Southern Pacific Railroad hires a lawyer by the name of Roscoe Conkling, who at the time was one of the most illustrious figures in American politics. He had been a leader of the Republican Party for over 20 years in Washington. He was a former senator and congressman. He had been nominated and confirmed to the United States Supreme Court twice. He turned down that opportunity both times. The second time was in 1882, the spring before he argued the Southern Pacific Railroad case in the Supreme Court. And so when the justices heard him making his argument, he had a lot of credibility, right? He was kind of a peer. He was someone who had been confirmed to the Supreme Court. He turned down the seat, by the way, because he said he was making too much money as a lawyer for the railroads to serve on the Supreme Court. He remains, by the way, Conkling remains to this day the last person to turn down a Supreme Court seat after having won confirmation in the Senate. And Conkling said that the framers of the 14th Amendment were intended to protect corporations, too. And he had incredible credibility making that claim, too. Not only was he thought of as a peer by the other justices, but Conkling had actually served on the committee in Congress that had drafted the 14th Amendment. So when he was talking about what the framers of the 14th Amendment intended, he was talking about his own personal experience, a very powerful testimony. Now, this was in some ways what he was admitting to was a constitutional conspiracy of the highest order. He was saying that corporations won important protections under the 14th Amendment, but no one in America knew it at the time, right? It kind of smuggled into the Constitution. And Ultimately, the Supreme Court, and he, by the way, he comes into the court and he produces a journal that was never before published journal that he claims was the unpublished journal of the deliberations of the 14th Amendment ratifying committee. And he said, if you look at my journal, you'll see that I'm right. It turns out that the Supreme Court held on to that case for like 3 years and never ruled on it, never gave the final decision on it until the case settled. There's some speculation as to why that happened. I suspect, though, that the court uncovered Conkling's fraud. His journal didn't say anything about protecting corporations at all. And so his argument was just not a very particularly strong one. But a couple years later, the Supreme Court, another one of the Southern Pacific's cases challenging that same law, making the same arguments, comes to the Supreme Court, but this time without Conkling involved and no mention of his journal. And the court in that case rules in favor of the Southern Pacific Railroad, although not on constitutional grounds. It specifically says we're not ruling on the constitutional merits. But nonetheless, the bureaucrat who publishes the court's opinions, a fellow by the name of, at the time, J.C. Bancroft Davis, published the opinion and included a summary, as the reporter traditionally does, right in front of the opinion. In the summary, he said that the court had decided in that case that corporations were persons under the 14th Amendment entitled to equal protection of the laws, something that the justices in the opinion clearly said that they did not rule. A couple years later after that, so we're still in the 1880s, a justice by the name of Stephen Field, who not well known today, but maybe the most colorful man ever to sit on the Supreme Court. He was the first justice from the Wild West, and appropriately, he carried a gun with him everywhere he went, even under his robes. And he's the only Supreme Court justice ever charged with a crime, ever arrested with a crime, not charged, but arrested for a crime while he was on the Supreme Court. And the crime was murder. So, I mean, this guy was a colorful character. He was innocent of the charge, of course. But he was determined to expand the 14th Amendment rights of corporations. He was in cahoots with Leland Stanford, the head of the Southern Pacific Railroad, was his good friend. He writes an opinion a couple years later where he just drops in a sentence. Well, as we held in the Southern Pacific Railroad cases, corporations are people under the 14th Amendment entitled to equal protection of the laws, something that the court clearly did not hold in the earlier case. But nonetheless, Field gets away with his sleight of hand for a few reasons, one of which is that the court's about to enter into the Lochner era, roughly 1890 to 1937, and the court reads during the Lochner era the Constitution very broadly to protect the rights of businesses. And the 14th Amendment becomes the key to that. And indeed, there's a study done in like 1912 that looked at every 14th Amendment case that came before the Supreme Court since 1868, when it was adopted. And the study found that there were a grand total of 28 Supreme Court cases on the 14th Amendment rights of African Americans, the intended beneficiaries of the 14th Amendment. And during that same period of time, over 312 cases on the constitutional rights of business corporations. So the 14th Amendment had been transformed from a shield to protect the newly freed slaves from discrimination into a sword used by big, powerful corporations like the Southern Pacific Railroad to strike down laws that regulated business. And really shows, I think, highlights that we imagine the Supreme Court as a bulwark for the protection of minorities. But historically, it's really been a bulwark for the protection of big business and corporate elites.
Well, I agree with that. And we should all, that's a great story, Adam. Thank you. And you did that beautifully. And it's beautifully told in the book, too. I also think we need to remind the listeners or viewers of this, that at the same time the court was protecting railroads, unintended beneficiaries of the 14th Amendment, to say the least, in Plessy, in the late 1890s, the court upholds a Louisiana law requiring the segregation of the races on public transportation. So, in fact, what the 14th Amendment was intended to do, the court reversed. Mm-hmm. And what it wasn't intended to do, it reinstated. And that's a lot of reasons why the court isn't a court, but I won't go there. So I do think if we jump ahead to 2008, when Citizens, whatever year it was, 2010, when Citizens United was decided, or modern times, I think most of us agree that let's take Exxon. Forget the New York Times. Let's take Exxon. The government is not allowed to break into Exxon headquarters and rummage through its stuff and do unreasonable searches and seizures without a warrant, without probable cause, because Exxon, and the only reason they can't do that is because Exxon does have some constitutional rights under the Fourth, Fifth, Sixth, Eighth Amendments, Fourth, Fifth, and Sixth Amendments, excuse me, or certainly the Fourth Amendment. And New York, and just like they could not, if the New York Times had no rights, it would have no right to publish editorials, and of course we know they do. So I think most people, I assume you agree with this, would accept today, corporations have rights, otherwise our country really couldn't be a democracy. Is that a fair statement?
I think that's actually a very fair statement, and it's one of the reasons I've objected to efforts to amend the Constitution to eliminate the rights of corporations.
You and me both.
There's a We the People amendment that's out there that's been proposed in Congress that would declare that corporations have no rights under the Constitution, that the rights only belong to natural people. I think this is a mistake for a couple of reasons, and one of which is, like you say, I think that corporations need to have some rights in America, right? They need a basic right of property, otherwise no one would form a corporation. Right. It's important to limit government power by recognizing that corporations should be free from unreasonable searches and seizures. We don't think the government should be able to seize Google's campus in Northern California and make it a public park without paying just compensation. And they shouldn't be able to just decide that Apple is guilty of some criminal offense without due process of law, without a criminal proceeding and proving beyond a reasonable doubt that Apple has done that. I think those are the kinds of rights that I think most people are not that troubled by corporate rights. Where the court's gone wrong, I think, has been expanding the freedom of political speech to corporations and the freedom of religion to corporations. Some of these rights are rights that just don't seem appropriate for corporations to have. I don't see corporations in church, like California's ban on in-person gatherings has been lifted. I don't think we're going to see Ronald McDonald showing up at a church with a jolly green giant right behind him. Right. So we don't see corporations practicing religion. It doesn't make sense to think of them, and it's important to limit corporate voice in American politics, because saying that they have an equal right to spend their money on politics when they have so much more money than people do is to take the wrong version of equality, I think. So I think what we need to have is a more nuanced approach to corporate rights, where we recognize that corporations have property rights and due process rights, but maybe not some of the liberty rights of political speech and religious freedom that are often thought to be at the heart of the Bill of Rights. That doesn't answer all the questions, right? There was a time in the early 1900s where the court said corporations have property rights but not liberty rights. I don't think that necessarily answers all the questions, but it's a good starting point for us to think about the problem of corporate rights.
Let's talk about Citizens United just for a minute, because I think we agree on it, but I'm not sure. So when Hillary Clinton wanted to make overturning Citizens United a litmus test, for her Supreme Court justices, at the time, I thought that was both a huge mistake politically, but leaving that aside, it's just wrong, because Citizens United is about a movie. It's not about giving money to anybody. It's not about political contributions or political expenditures. It's about a nonprofit ideological company that made a movie that the government said it couldn't distribute. I don't view that as any different than the New York Times publishing an editorial. And I think the result in Citizens United, that this movie had a right to be displayed, I think that's the correct result. Where the court went wrong is everything else it said in that case. And the fact that the New York Times has a right to publish op-eds doesn't mean the New York Times has the right to give unlimited money to a candidate or even spend unlimited money on behalf of candidates. So I think with Citizens United, it could have been very narrow. Instead, it went very broad. And then and it's been downhill ever since. Do you agree with that assessment?
I do agree that there was a lot of narrower ways that the court could have ruled in Citizens United and recognized some ability for the Citizens United organization to promote this movie. I will say that just as a matter of legality and legal norms and sort of legal rules, it wasn't exactly, a nonprofit membership organization that was taking out political expenditures. Under the court's pre-Citizens United jurisprudence, under Massachusetts Citizens for Life, a case decided, I think, in the 1990s, early 1990s, maybe late 1980s, the court held that Nonprofit membership organizations, even if they take the corporate form, are allowed to spend their money on politics because that's why you give money to one of these organizations.
Right.
The difference is that Citizens United, while it was one of those types of companies, well, it was those types of corporations, a nonprofit membership organization, it was using money that it had received from for-profit business corporations. And I do think we don't want to create a system in which for-profit business corporations can skirt the obligation to avoid making political expenditures by just giving it to a nonprofit to have the nonprofit spend it for them, right? That's a kind of big loophole in American politics. But you're absolutely right. There are more narrow ways the court could have gone about the Citizens United decision and didn't have to do what it did. We should also note that a lot of what gets associated with Citizens United comes from other cases that have come after Citizens United. So, for instance, Citizens United didn't do much on its own to promote this era of dark money, huge, hidden, untransparent, unaccountable amounts of money going into the electoral process. That's really more about a case that was in the DC Circuit after Citizens United, where the court definitely relied on Citizens United partly for its logic. But I think sort of the biggest problem with money in politics in America today is not so much Citizens United, but Buckley versus Vallejo, where the Supreme Court in the 1970s said that people can spend unlimited amounts of money to, as long as they don't act in coordination with a candidate, to advance that candidate's election. And that's what's led to the big expenditures, the Sheldon Adelson spending $90 million. There shouldn't be a system in which one man can spend $90 million and everyone else who unfortunately doesn't have $90 million. Can't do that.
I agree. And I often say it's the McCutcheon decision that came after Citizens United that really makes me almost even angrier, because at least Citizens United involved a movie, which is speech, protected speech. McCutcheon involves a guy in Alabama writing a check to a politician in California, and the court called that speech. Now, I admit writing a check to a politician might facilitate that politician's speech. It might not, but it might. But it's not itself speech. Writing a check to a plumber is not speech. And equating that check writing to speech is just another one of the many kind of overly broad rules the court has made up, not based on text, not based on history. I think you'd agree with that, but based on values and politics, right?
Agreed.
And we're back to where we've been all hour, which is money speaks. So let's go to an area where actually money does speak, but a little bit less, but a little bit not quite as directly. So your book, Gunfight, The Battle Over the Right to Bear Arms in America. This is an amazing thing, but I think it is from both liberals and conservatives that I've talked to over the years on countless radio shows, podcasts, TV interviews. They all agree this is the best book ever written on gun rights. And you've got to feel good about that, because I've never met anyone who said, wow, that wasn't that good. Like, no one's ever said that about this book. It's an amazing thing. We don't have a lot of time left, Adam. So your dad produced Rocky, I believe, the movie Rocky. Rocky 3 is the one with Mr. T in it, I believe. And
That's right.
This is my statement about what's coming up with the Second Amendment, and then I would like your reaction to it. In Rocky 3, Mr. T was asked, what's your prediction for the fight? And he turned to the camera and went, pain. That's how I feel about the future of Second Amendment rights in this country. You think I'm right? Do you think I'm wrong?
I think you're right. There's another line in that movie where that might be appropriate for gun control advocates these days, which is where Mr. T says, I pity the fool.
Right.
That's right.
Right.
Yeah, you know what? The truth is, it's a really interesting time in American politics. First of all, thanks very much for the kind words about the book. It's really it's a tremendous honor to hear that. But I do think we're at a very, very interesting time in American gun politics. We have seen since Newtown in 2012 the reinvigoration of the gun safety reform movement. The gun control movement was kind of dead in America for the last 30 years or so. And although we haven't seen any significant new federal laws since Newtown in 2012, we have seen the reemergence of a real vigorous gun control movement. We see organizations like Everytown for Gun Safety having been formed, Gifford's group and its super PAC. We see money going into politics. It used to be 20 years ago, all the money that was going into gun-related politics on election day came from the pro-gun NRA side. Well, we're now seeing a lot more expenditures from the gun control side, and we're seeing a lot of mobilization among gun control advocates. Moms Demand Action has been with
Right.
a real force, I think, in the 2020 election and in the 2018 midterm elections. So we see this real new invigoration. We see Joe Biden has his website during the campaign had a very aggressive set of gun reform proposals. So we see this new movement and this new energy for gun control. At the same time, we've seen the Supreme Court now with its new Trump justices clearly about to go the other way and to create new limits on what we, the people, can do in terms of regulating guns. And I think that's an area that we're likely to see significant movement, significant growth. We talked earlier in the show about religious liberty being an area where the court's likely to expand the rights of religious liberty. I think we're also going to see the court likely expand the rights of gun owners, call into question things like not all of our gun laws. I don't think that's that apocryphal vision is not going to happen, but I do think we are going to see the court call into question laws that restrict concealed carry in states like California, New York, and Massachusetts. We're likely to see the court call into question some laws that prohibit military-style assault rifles or high-capacity magazines. And so we are likely to see some curtailment of America's gun laws in light of this new Supreme Court majority. And so I think that issue is just going to continue to be at the forefront.
The irony for me on that, I think there's going to be a big decision in the next couple of years, and it's going to be very injurious to gun reform. Unless there's another disaster, if there's, I don't want there to be another disaster. If there's another school shooting of terrible sorrow, then I think the court might wait. But leaving that aside, I think you're dead right on your prediction. And what makes me so angry about it is leaving aside the possibility that I think you've raised, that if one believes in substantive due process under the 14th Amendment, which is where the right to abortion comes from, I don't believe in that, but if one does believe in that, then I think the right to own a gun in America would be a candidate for that kind of treatment. But there is no even close to legitimate argument that the Second Amendment was meant to give people the right to own guns in their houses, at least not from any respectable historian that I've seen. So the idea that this quasi-pseudo-hypocritical originalist court is going to read the Second Amendment in a way completely at odds with its history is almost too much to bear. That's all right, Adam. We only have 5 minutes left. I didn't tell you. I didn't ask you in advance if I could ask this question directly, and I'm going to ask it. So as we mentioned earlier, let's end on a lighter note. So you grew up in a Hollywood family. Your dad is a famous Academy Award-winning producer. As I mentioned earlier, Rocky, The Right Stuff, a ton of other movies. The Irishman just a couple of years ago. I think The Right Stuff is one of the most underrated movies ever made. I think it's fantastic. When you were growing up, so here's my 5-minute question. Do you have a good story about Hollywood that you could share that you haven't shared a million times, that you could, just something funny that happened to you because of your dad's success and career?
Well, yeah, I guess so. I mean, I don't know how funny it is, but yeah, I did grow up on a Hollywood family. Spent a lot of time as a kid growing up on film sets and things like that, and saw a lot of celebrities when I was growing up, and they would come to our house and whatnot. And it was an interesting time, to be sure. But when I was in 4th grade, my dad put me in one of his movies, and I had a speaking role in one of his movies. It was a movie called New York, New York, which was not a very good movie.
I remember it, though. I remember it.
Well, there you go. It was a musical directed by Martin Scorsese, starring Robert De Niro and Liza Minnelli. And the movie, it was the kind of musical only Martin Scorsese could make. It was about a wife beater, right? That's the Scorsese kind of musical. But the movie is kind of only known these days, really, for the famous song "New York, New York" that Frank Sinatra really made popular in the wake of the movie. That was written for the movie and first performed in the movie.
Wow. My
funny story is only that I had this small part, and I played the son of Robert De Niro and Liza Minnelli. And I've still got some great pictures of them. And it was, when I worked, I was young. I was only in 4th grade, but I was in a major motion picture with Robert De Niro and Martin Scorsese. I figured I had reached the top of the film game and needed to find something else to do with my career. And so here I am.
You peaked early. That is funny. I'm a huge Scorsese fan. I think your dad did Goodfellas as well, which I think is one of the great movies also of all
Raging
time.
Bull with Scorsese, which was also a great one.
So let me just throw a couple quick questions at you, and then we'll go. Have you met Pacino?
I've met Al Pacino. Al Pacino was in a movie that my dad did called Revolution. Not a good
Yeah.
movie, unfortunately, but he starred in a movie that my dad did called Revolution, and I did get the chance to meet him a few times associated with that movie.
I want you to tell me he's a nice guy in person. Can you tell me that?
Well, I really can't speak to how he is, outside of a work. I met him in a work context, and I was
Okay.
the son of the producer of the movie.
Okay.
So he was very nice to me, and he was very charming and nice. But I don't know how he might be at dinner. I will say that the personality of actors, as a general matter, and this is not a reflection of Al Pacino in any way, but the personality traits of actors was exactly the kind of thing that pushed me from going into the film business, and becoming an academic instead.
So my sister went to Sarah Lawrence from 1974 to 78. Sarah Lawrence at the time was one of the best, maybe still is, one of the best theater, acting colleges in the country, next to Yale maybe, and a couple others. And she and about 10 of her friends went to Hollywood to try to make it. They were all really talented. My sister actually was pretty talented. And she even had connections through my dad, who worked at American Express. And I met a lot of her and her friends when I was in college during that time period. And what I'll never forget about it, and what I think to me sums up what you were just saying, I think, is when I got to LA, my sister and I grew up in New York. She was from New York her entire life, except being born in Canada. She introduced me very dramatically as my brother from the East. And I went from the East. And I went to look at her and say, I'm not from China. I mean, what do you mean? I'm from the East. And all of their reactions were so over the top that it was fun for like an hour. And then I got so tired, and I was like 19. Is that a fair dramatization of kind of, not, I mean, it's a true story, but I feel like it feels that way a lot. Is that probably true?
Hollywood people are a little bit over the top. I think that's
Okay.
fair to say.
Adam, thank you so much for doing this. I wish we had more time. I really appreciate it. You and I have done a lot of things in person together, and when COVID ends, we're going to do that again. I promise. And thanks so much for coming on.
I'm looking forward to it. And Eric, thanks for doing this. Thanks for having me on. And thanks for doing this show. I think it's great for people like me who have a real interest in constitutional law and in the Supreme Court to get the kind of critical vision and critical commentary that you provide and the guests that you bring on provide. So I think you're doing a great service, and happy to participate in my small way.
I really appreciate it. Thanks, Adam.